State, would you please set a record for James Broadway?
Yes, Your Honor. Thank you. This is State of Indiana versus James Broadway. There are two cause numbers, 64D01-2602F61333 and 64D01-2602F61636. The defendant is present in court in person by video conferencing without counsel. State of Indiana by Gary Gurman.
Morning, Mr. Broadway. Can you hear me okay? So first, I'm required to advise you of your various rights in this matter. You have the right to hire an attorney to represent you. You have the right to have an attorney appointed to represent you if you cannot afford an attorney. You have the right to a public and speedy trial by jury, and you have the right against self-incrimination. That means you could not be forced to make any statement or testify against yourself at any hearing or trial held in this matter. You understand those rights as I've just gone through them?
Sure.
Okay, and you've been charged here in F61333 with one count. This cause states that on or about February 4th, 2026 in Porter County, you did knowingly or intentionally, it's actually on February 5th, 2026 in Porter County, that you did knowingly or intentionally exert unauthorized control over a Laura Geller Compact Foundation belonging to a Jennifer Badola by taking the package from her porch and with the intent to deprive her of any part of the property's value or use, and that upon a criminal records check, law enforcement determined that you have a prior unrelated conviction for theft or conversion from 2018 in Porter County. You understand that allegation?
Yes, I returned that package to.
Sir, do you understand what they allege you did?
Yes, and I returned it to the police officer, and he said he was not going to charge me with anything.
What's important for me to know is that you understand what they allege.
Yes.
Okay. And it's charged as a level 6 felony, which carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. You understand that possible penalty?
Yes, I want to go pro se.
Okay, let me get into the next part first.
But I just
First, I'm going to enter a preliminary plea of not guilty for you on count 1. And then the state filed on February 25th a habitual offender enhancement.
Buckle up, guys. Today we're diving into 2 hearings, and the first one is an update on a defendant who already learned the hard way what happens when you mouth off in court. The narrator reminds us this guy caught 6 months for disrespecting a judge, and now he's back again. Same attitude, new trouble, and the setup screams another courtroom blow-up.
Have you received a copy of that?
I haven't received nothing. Can I say something?
Go ahead.
This case that you're talking about is a summons for March 20th. We're not even talking about why I'm here when I got transferred. That's what I don't understand. That's why I fired off at you.
Yeah, I understand, Mr. Broadway. Like I explained the first time we met, the summons went out, but because you were already in jail, they wanted to make things convenient. So they just wanted me to do the initial hearing while you were already in custody, which was fine with me. So the February, what was it, 20th or whatever date the summons date was, that was vacated. March 20th. So you don't have to be here on March 20th. That date was vacated.
That means your speedy trial is something that I'm still talking about why I'm here. From Speedway and the possession charge was Clymer transferred me to you for that charge. And none of that is being discussed right now. I have 3 different cases going on. I got a Toadies case with false informing, and we got pulled. We didn't even get pulled over. We ran out of gas, and they said they were going to help us. And then now I came here, got re-OR, and I'm say. So I just want to go home, sir. And we can do this.
Mr. Broadway. You keep doing a couple things which you need to stop doing. One is that you keep talking about your defenses out loud in front of the prosecutor. You should not do that. You should only talk to about your defenses in front of your attorney. If you're going to represent yourself, you need to do that in some proceeding other than in front of me, because I don't need to hear any defenses until your cases go to trial. You talked about the pending case you have in front of Judge Toady. I'm aware of that.
The judge lays out the porch package theft like a clean timeline, what was taken, whose it was, and the prior theft that makes it worse. But the defendant can't help himself. He blurts that he returned it, tries to argue the officer's promise, and even hints at representing himself. The judge keeps snapping it back to one point. Understand the allegation first.
They also say that on January the 6th, 2012, in Porter County, you were convicted of a felony in case 64D01-1108-FD-7679, intimidation, a Class D felony, committed on August 12, 2011, and that based upon that conviction, were sentenced on January the 6th, 2012, to time served in the Porter County Jail. They also say that on December the 1st, 2003, in Porter County, you were convicted of a felony in cause 64D01-0010-DF-8173, possession of marijuana, a Class D felony, which occurred on 26th of September 2000, and that based on that conviction, you were sentenced on December 1st, 2003, to time served in the Porter County Jail. Do you understand what they allege are your prior convictions related to the habitual offender enhancement notice? Do you understand what they allege?
No, I don't. That's not my charges. That's not me. My name is Jamie Clifford Broadway. Not James Clifford Broadway. Jamie Clifford Broadway.
My name is Jamie Clifford Broadway. Get that right. My name was changed when we came back from
Another
the war,
30
sir.
days.
Okay, sir.
Explain
That's
that.
what the state alleges for the habitual offender enhancement notice.
They made my charges.
Do you understand what they allege?
I understand that. I hear that, but
Okay.
I don't agree with it.
I understand, and nobody's gonna. In a few minutes, I'll enter a not guilty plea for you on it because you're innocent until proven guilty in this country.
The defendant spirals into confusion, mixing cases, dates, and why he's even there, basically talking himself into a mess. The judge explains the court moved the hearing because he was already in custody, then delivers a key warning. Stop saying defenses out loud with the prosecutor listening. It's a calm reminder that court isn't therapy, it's strategy.
You said you want to proceed pro se.
Like
You
this,
wanna
I
proceed
don't understand
pro se?
why you can't OR me and I be in court with my suit or tie.
And he will have to conduct a Feretta hearing related to the pro se. But in the meantime, I believe I have a duty to make sure you have an attorney within 20 days of being arrested.
I don't want an attorney,
And
sir.
I'm going to appoint the Porter County Public Defender Service
I
for
don't
you.
want that. I'm my own attorney. You know that. So does Judge Toady.
I don't
It's
think
so
you can get a
simple.
Feretta
It
hearing,
is so simple. I'm not a flight risk. You all know where I live at. I'm sorry
you're
for
in jail
raising
now
my
because I
voice,
sentenced
but I'm
you to-
always put as a different in this place.
for your contempt last Friday.
I
transferring the
don't
case.
call
We
that
have a
being.
hearing on June the
You said
15th.
something about
Go to
chickens, sir.
Judge Cody.
That is not professional.
We're
You
adjourned.
gotta have more of me and no, I'm not.
The temperature spikes when a habitual offender history is read out, multiple priors, multiple years, and real time at stake. The defendant tries a name switch, insisting he's Jamie, not James, like that erases the record. The judge fires back with sarcasm, reminding him the court has receipts, including video. It's a classic Dodge collapsing in real time. The defendant pushes the I'm my own lawyer angle, complaining he doesn't want a public defender and claiming he's not a flight risk. He wants to show up dressed right, like appearance changes the facts. The judge stays in control. A Faretta hearing can happen later, but for now counsel gets appointed, and the judge ends with a sharp send-off back to jail.
Court will call People versus Ryan Wagster, 26 CR 323. Hello, sir. Are you Ryan Wagster?
Yes, sir, I am.
Did you understand your rights in the advisement?
Yes,
Have you ever been in the U.S. military?
no,
Charges are third degree. Actually, it looks like maybe the charges are still being decided. But allegations are third degree assault and attempted robbery. Do you understand the nature of the allegations?
yes,
I reviewed the affidavit. I found probable cause for the arrest. I will issue the protection order. This is a VRA matter. Do not harass, molest, intimidate, retaliate against, or tamper with any victim or witness. Vacate the home of the victim. Stay away from the home of the victim, but also stay away from any location that the victim might be found. no contact whatsoever, and do not directly or indirectly communicate with the victim. No contact whatsoever, based on the fact that this occurred at her business. Ms. O'Hara, even if I did know the home address, I would not list it. Any quarrel with that?
No, Your Honor.
All right, bond argument, Ms. O'Hara?
Your Honor, the defendant does have a very lengthy criminal history dating back into the 90s, and it does include felony attempted second-degree assault, attempted burglary, a menacing as a felony, a second-degree assault as a felony, along with other misdemeanors on his record, thefts, harassments, violation of protection orders, things of that nature. Obviously, the facts of this case are very concerning to the people based upon the fact that the victim in this matter, as well as Mr. Perez, were simply doing their job and working at the Family Dollar, and were attempting to confront the defendant about the potential for a theft when the defendant punched the victim. So obviously that is very concerning and is an extremely aggravated case, I guess. So it went from what could have been a simple theft to now something much more serious, and it could be something even more serious. I don't know the extent of the injuries to the victim, if there was anything more substantial. But based upon all of that, I am asking for a $25,000 cash or surety bond with pretrial.
Bond argument, Mr. Duran?
Thank you, Judge. What I can say, as the court's well aware, is that this case is alleged to have been from May of 2025, and there was, it appears, recent identification attempts based on the detectives from Greeley Police Department in the affidavit. What I can say is there hasn't been additional cases or law enforcement contact or anything at this time. As far as we know, Mr. Wagster was compliant with officers. I can say that most of what the district attorney noted in the argument were, from what I could see, misdemeanor, previous criminal history, unrelated previous criminal history to this type of charge, and, as she noted, relatively old. I can also say that Mr. Wagster lives in a house here in Greeley that he owns.
The second case hits its peak. The judge refuses to reward someone who didn't face the situation sooner, calls the allegation serious, and locks in a $25,000 cash bond with strict conditions.
Well, he may have thought that whatever the issues were, they were put to rest. So I don't know if I agree with complete surprise. It's just that it came now is probably not all that convenient, but he could have stuck around, assuming it was him and this really happened. He could have dealt with the police then. So I don't reward someone for basically remaining at large for 8 months on something where he's alleged to have basically hit somebody because they had the audacity to ask him, are you going to pay for that? And really elevates in about one short 2-second decision what's probably a petty shoplifting theft in a municipal court into much more serious charges against his backdrop. And I don't know if what you were trying to say is you don't think he has prior felonies, because it looks to me like there was a prior burglary and a stint in DOC. That by definition would be a felony. I certainly understand it's less convenient now for him, but to me, that doesn't garner any points for him, that he hasn't committed any other offenses or we would have caught him sooner. So this caught up to him now. That's just the way it is. This is more than your run-of-the-mill third-degree assault. Court is going to set bond the amount of $25,000 cash or surety with pretrial services, monitored sobriety, appear at all future court
Excuse me, can I
dates
say
to
something here?
comply with the
Mr.
mandatory
Waxer.
protection
You
order,
were saying I
do not
was on the
violate
clock.
state, federal, and municipal laws. What's that, sir?
Can I say something here? I mean,
Mr. Wagster,
you
Mr.
guys had
Wagster,
me fully.
Mr. Wagster, Mr.
No,
Wagster.
you had get your chance to say something. I have something to say here. This is not fair. You're making it sound like I was on the run and evading everything. This wasn't even filed until Tuesday. I had no idea that this even existed. I mean, you're making it sound like I was evading and running everywhere. And I don't even know what this is going on. This is not fair, Your Honor.
Okay. Well, your attorney can take it from there. If you don't want the public defender, you can hire your own attorney. Return of charges February 24th at 3:30 in the clerk's office if you bond out. March 2nd at 3:30, you'll be in front of the district court. You can certainly lay that out to them. You have a long criminal history, and these are pretty serious allegations, so that's where we are today. That's it for today.
I don't even know what they're fucking talking about, man. Fuck that dude, man. You want to see?
Thank you.
When the defendant tries to protest, the judge drops a brutal one-liner. Then the hot mic frustration spills into open disrespect. If you enjoyed this, like the video, subscribe to the channel, and we'll see you in the next video.